It may seem intimidating to create a last will and testament that will be legally binding in Kansas without seeking legal advice. However, with the right guidance, drafting an official will can be rather simple and straightforward. In this video, we'll cover the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Kansas, and how and where to create an official will. Let's begin first by looking at wills and their importance. A last will and testament, also simply known as a will, is perhaps the most crucial estate planning document. It allows an individual to set after-death instructions on the distribution of their assets among family, friends, and other beneficiaries. It's highly recommended that all adults create a will, particularly those who are elderly or challenged by a fatal disease. Now, what occurs if no will is left? A person who passes away without a will loses full control of who inherits their property. Instead, Kansas law dictates how the deceased's assets are handled, which in most cases leads to the deceased spouse, children, or blood relatives inheriting the property by default. Disputes can unfortunately arise between loved ones regarding who is the rightful heir to certain property if no will is in place. Fortunately, potential disputes can be avoided by making a clear will document, and often without an expensive attorney required. A person of sound mind can draft a will in Kansas with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's review some legal requirements in Kansas. Last will and testaments in Kansas must be signed by the person to whom the will belongs, known as the testator, in the presence of at least 2 trusted and competent witnesses. Though it is optional, it is recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once created and signed, the document will be legally binding. Multiple copies can be made and given to trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We have created state-specific last will and testament templates specifically designed for Kansas that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.